While Florida and the Caribbean islands were suffering the after effects of Hurricane Irma, the U.S. House of Representatives Committee on Ways and Means Subcommittee on Oversight held a hearing on reforming the way the IRS handles disputes with taxpayers. This is much needed reform, and it could mean that having penalties abated will be a faster and fairer process for tax-exempt organizations as well as for other kinds of filers. Chastity Wilson, a CPA, testified on behalf of the American Institute of CPAs on several topics, including penalty abatement, which is the focus of this video. Links to the entire video of the hearing and to the written testimony submitted by the witnesses can be found below this video if you're watching this on YouTube, or on my blog below the video if you're watching on my blog. Ms. Wilson's main points were that frequently the initial IRS response to the taxpayer's request for penalty relief is to just deny abatement without full consideration of the taxpayer's technical arguments or of the evidence submitted in support of reasonable cause. Also, that the IRS personnel assigned to penalty notices often don't have the training or expertise needed to review the taxpayer's written request for penalty relief, and that the IRS has been routinely denying taxpayer requests for face-to-face appeal hearings since 2016. Let's hear what she has to say about these points.
First, let's start with penalties. Upon receipt of an IRS notice, taxpayers or their representatives may determine a reporting error was made. However, if the taxpayer made the effort to comply with the reporting requirements, the taxpayer may request relief from penalties. Frequently, the initial IRS response is a routine denial.
I have always found that with Form 990 late filing penalties, the IRS is more generous in waiving penalties as long as a proper reasonable cause letter is submitted. However, even with nonprofit organizations, penalties involving payroll tax returns or 1099 information returns are much harder to resolve and are more likely to require that a follow-up letter be sent to the appeals coordinator after initial denial.
In another appeals case, payroll obligations were not met until my client discovered the error. The appeals officer said it took him a whole 5 minutes to determine there was no reasonable cause and asked not to discuss it. In this particular situation, a conversation, much less a face-to-face conference, was considered unnecessary from his perspective. However, from the client's perspective, he was not heard. He was unfairly denied the right to present his case. While it's possible to resolve some issues over the telephone, we think it is important that taxpayers have the option of a face-to-face conference.
Here's an example of a response my client, who was a bookkeeper, received from the IRS after we sent a 16-page reasonable cause letter to the IRS requesting abatement of penalties because the corporation filed their 1099s on paper instead of electronically as they were supposed to do. The information submitted doesn't establish reasonable cause or show due diligence. Therefore, we must deny your request for penalty abatement. We could not grant your request for abatement because the failure to file Forms 1099 electronically was due to being unaware of the electronic filing requirement as stated in your correspondence. It is the taxpayer's responsibility to obtain information on filing requirements by visiting our website at www.irs.gov. Therefore, the penalty remains as proposed. Then they gave us the option of sending a letter to the appeals coordinator who would read the letter and determine if the penalty should be removed, and if not, they would send the letter onto the appeals office. Note that the IRS form letter characterized our reason as ignorance of the law. Now, it was clear that the IRS employee did not read or didn't understand our lengthy argument, which did much more than just claim ignorance. So I followed up by sending the same letter to the appeals coordinator with an introductory paragraph saying that it was clear that our evidence and argument in the first letter were not given proper consideration, and that the taxpayer had a right to have all of the relevant facts and circumstances taken into account. 60 days later, we received a letter waiving the penalty. Here are some of the suggestions put forth in the hearing for improving the way the IRS responds to requests for penalty abatement. First, the IRS should be required in all cases to justify, in writing to the taxpayer, why the penalty relief was not granted. Second, the reason should address the evidence presented and the position taken by the taxpayer to support reasonable cause, and should not be primarily a canned, impersonal form letter response. Finally, if the taxpayer's initial request for penalty relief can be addressed properly by trained IRS personnel, they believe that the number of requests for appeals hearings can be reduced, and the costs to the filers and to the IRS can be reduced.
Should we be requiring that if there is an original inquiry and there's a routine no set out, that there's a justification that you can know that somebody's actually analyzed the file and said that there's a reason why we're just saying no right now?
I would absolutely agree with you that there should be a requirement to, document what the justification for denial was. And again, there's many a times where we do get the denial and it does appear somebody's reviewed it because they put specific facts in there.
But you're comfortable with that because at least you know you can counsel your client. Here's what it's...
Yeah. But there's been instances where it wasn't read because they've articulated, the way, and maybe Ms. Peronchek can speak to this, but they'll take paragraphs. They've got modeled paragraphs that they can pull from a system to do a notice to a specific taxpayer. And it's been obvious that they just pull those paragraphs and dump them into this letter, and it's very irrelevant to what was even discussed.
So what's the effect on the taxpayer? It just draws it out even further. Have penalties and fines been waived during this period, or is there a further accumulation during the period of time that you're appealing this process?
So yeah, interest continues to accrue while we're going through this process.
So the clock's ticking against the person who's appealing.
Yes.
So here's my final thought on the hearing and how it might affect penalty abatement requests for nonprofits especially. It's great that Congress is attempting to reform the penalty abatement procedures within the IRS. But the best we can hope for is that the IRS will assign better trained personnel who will have the expertise to evaluate the reasonable cause criteria on a case-by-case basis without forcing the filer to use the appeals process. Showing reasonable cause for late filing is both an art and a science, and it's usually beyond the layperson or even many CPAs. And this is not likely to change. Get a professional to help you write a reasonable cause abatement request letter and to shepherd you through the process. Don't face the IRS alone. I'll be glad to help you get relief from late filing penalties for IRS Form 990, or to help you explain a failure to file a return for 3 consecutive years in your application for retroactive reinstatement of tax-exempt status. I also offer very detailed materials on how to write a reasonable cause letter to the IRS, along with many sample letters. This is do-it-yourself materials and very helpful if you want to go this alone. You can contact me via email at david.mccree.cpa@gmail.com, or you can use the contact form on my websites, form990help.com or nonprofittaxguide.com. Thanks for listening.